First, we would like to acknowledge that we are meeting on the unceded traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, which is now home to many diverse First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit. We encourage everyone to learn whose territory you live on and work on, and if you're able, to support the work of an Indigenous-led organization operating here. If you're local to Darchei Noam, you'll find some good places to start at the Toronto Aboriginal Support Services Council. And now, in a few minutes, we will be hearing from James Lockyer on wrongful convictions in Canada, why they happen so often, and what can be done to prevent them. Mr. Lockyer will talk for about an hour, followed by questions from you. And I say questions, and questions have an interrogatory and a question mark. Okay? We will have time to schmooze at the reception after. So on your seats, you may be sitting on them, there are index cards, and in fact, there are also pens on some of the chairs, and we can all share. So feel free to jot down your questions. And Mr. Lockyer will talk for about an hour, and then we will collect those questions at the end of his remarks. For those of you on Zoom, you can submit your questions anytime by using the chat function to send a message to Sylvia Hunter. I'll tell you a little bit more about Mr. Lockyer and his illustrious career in a few minutes, but first I'm going to turn the proceedings over to our Rabbi Tina Grimberg to welcome you and to tell you more about the Merkur Lectures. Rabbi Grimberg is very sorry she can't be with us tonight, and she prepared these remarks.
Good evening and welcome to this evening's Merkur Lecture. Thank you for being here. To our Darchei Noam members and to all our guests, warmest welcome. We are honored this evening with an opportunity to learn and to expand and to have our soul strings touched and moved by a sense of justice and kindness. I would like to thank our speaker this evening, James Lockyer. Welcome to Darchei Noam. I would have loved to be with you this evening, but I'm in Boston and there for a family celebration. I am very sad not to be able to turn to my dear friend, Lauren Merkur, and say to him, Lauren, I don't do this often enough. How can I do this better? We lost Lauren less than 2 months ago. My dearest friend was the man of justice, incredible moral compass, and kindness. I know that in the audience, his mother, Myra Merkur, our longtime member and my dearest friend, as well as Lauren's children. I would like to say to his family who are tapping into this event, either tonight or later on in the recording, how much both your loss and your incredible gain of having Lauren in your life speaks volumes. I remember when this idea of Merkur Lectures came to be. It was COVID, and Lauren and I took a long walk in Earl Bales Park, wearing an elegant beige cap and a jacket. Lauren said to me, I would like to make a gift. I was a lucky boy who was born and raised in a plentiful household in the city of Toronto. And the city and its people mean a lot to me. And I want to dedicate a yearly lecture to be able to help us to grow in understanding and to create and to raise awareness of who we are as people, as Torontonians, as Jewish community, and as a family at Darchei Noam. it was a wonderful walk, filled with beautiful trees that sang along to the words of justice. Lauren, of blessed memory, created something that draws all of you here tonight. Along with your ache, may the words of our speaker this evening also elevate you, and may Lauren's memory be of blessing. I have a favorite teaching from Pirkei Avot, sayings of the fathers, of our sages, where our rabbis strongly feel that our home should be the home that gathers wise people. And they say to us, may your home always be a home for those who are wise and kind. Sit at their feet and drink their words with thirst. Lauren, of blessed memory, wanted to make sure that this congregation, Darchei Noam, for whom he cared and respected its intellectual, its sensibility of social justice, and these incredible people who make this community continue to be a home where wise people can come and we sit at their feet and drink their words with thirst. Tonight, may it be an evening when we do exactly that. Welcome, and may it be a night of meaning.
Pleasure to introduce and welcome James Lockyer. And before I get to the meat of that, I'm just going to have a quick reminder for everyone to please put your phones on silent so we can absorb the wisdom without any distractions. Our justice system is under all kinds of pressures, understaffing, unconscionably long wait times for trials, a possible prime minister who has hinted he would invoke the notwithstanding clause to pass legislation, some of which would have to do with crime and sentencing. All of this will not help what is already a reality our speaker has spent a lifetime addressing: wrongful convictions. Mr. Lockyer has been a criminal lawyer for 45 years. For the last 30 or so, much of his practice has involved unraveling wrongful convictions. He's a founding director of Innocence Canada and has led or participated in more than 30 high-profile cases exonerating falsely convicted persons of murder. These include overturned convictions of Guy Palmarin, David Milgaard, Stephen Truscott, Robert Baltovich, and Romeo Fillion. In recognition of this work, he has received numerous awards and was named a member of the Order of Canada in 2018. And again, a quick reminder, phones off, and to jot down your questions as they come to you, to be collected at the end of his presentation. And now, Mr. Lockyer, over to you.
Thank you. Just going to check my phone's turned off. It is. Well, a real pleasure to meet the Merkur family just a few minutes ago. Mom and his brother and his children. And of course, a real privilege to be invited here. And there's something very special about speaking in a place of worship. I don't consider myself particularly religious, but to speak in a place of worship makes you think about faith, makes you think about justice, makes you think about goodness. I was casting my mind back to a couple of other times I've spoken in synagogues. Once I spoke at the Emmanuel synagogue, not far from here. I remember the very first time. I don't remember the name of the synagogue, but it was back in 1979, and I was running federally for the NDP in the riding of St. Paul's, a complete lost cause for the NDP. I doubled the vote, but still lost my deposit. I was running against Ron Atke and John Roberts. Those of you of my age may remember those names. And I spoke, one of the all-candidates meetings was in a synagogue, and I remember I was only 29 years of age at the time, and I remember feeling very intimidated back then. One of the most moving times I spoke in a place of worship was at St. James's Cathedral downtown, when I shared a stage with Sister Helen Préjean, the nun who became one of the best known, if not the best known, advocate against the death penalty in the United States. She was with us, and she was played. I was just looking it up. You may have heard it on the mic before we started. She was played by Susan Sarandon in the film Dead Man Walking. One of the more unusual times I spoke in a place of worship was down in a small, tiny little church, Anglican church, in Smithville in the Niagara region. It's very much a farming area. And I was invited to go and give the sermon on Sunday one morning. And I went down, and much to the bewilderment of the farmers to whom I was speaking, I spoke about how we needed to abolish the death penalty around the world. Not something that they thought about too often, I don't think, and not even something they necessarily agree with me, but they were very nice about it. When you think about wrongful convictions, the first thing is you should know they're timeless, inevitable, and of course without borders. Indeed, just yesterday, I was reading about a man who had spent 14 years in a Brazilian jail as a serial rapist for crimes that it was eventually realized he had not committed. When you think of wrongful convictions, two things very quickly come to the fore. One is, how do we find them and correct them? The other is, how do we limit them in the future? And notice I say limit them, because there always will be wrongful convictions. The justice system is a very human system, perhaps as human a system as there is today. Dependent on its constituent components, which are a host of human beings in different professions, coming from different walks of life, and we hope they all get it right. Because it might only take one of them to get it wrong, to have a wrongful conviction. Take a murder case and think how many parts there are to a murder case. There are so many things that can go wrong. You may even think it's something of a testament to our system that we don't get it wrong more often than we do. Fortunately, most murders, or certainly the majority of murders, the people who committed them leave behind prints, whether literally or figuratively, which enable them to be quickly identified. But where this doesn't happen, then a very complex process takes place. And it begins with the pathologists, very often. Was there ever a murder in the first place? Is a question that has come up in many wrongful convictions. And indeed, in Canada, the pathologist profession, members of the profession, have been responsible for many of our wrongful convictions. A familiar name of Dr. Charles Smith, he alone was responsible for 11 wrongful convictions in child deaths and we're still counting. The pathologist can send a case in the wrong direction very quickly. One of the more unusual cases in which we were involved at Innocence Canada was the case of a man called Jacques Delisle. And what was so unusual about his case was who he was. For 13 years before his arrest, he'd been a judge of the Quebec Court of Appeal, the highest court in the province. And on November the 10th of 2009, his wife died as a result of a bullet wound to her head. And 7 months later, her husband, Jacques Delisle, was charged with her first-degree murder. And on June 14th, 2012, he was convicted of her murder and sentenced to life without eligibility for parole for 25 years. His case was a case where the pathologist got it wrong. The pathologist decided very quickly, in an extraordinary rush to judgment, that Jacques Delisle's wife had been murdered when it was quite obvious, you would think, to anyone who looked at the scene, that she had committed suicide. But the murder theory was based on one fact, and one fact alone. And that was that when the police arrived, Jacques Delisle had gunshot residue at the base of the palm, Nicole Rainville, the deceased, I meant to say, had gunshot residue at the base of the palm of her hand. And a lot of it, a very clear parabola, if you like, of gunshot residue. The bullet was found at the back of her head. The entrance wound was found in her left temple. The pathologist immediately jumped to the conclusion that in order to have killed herself, she must have shot herself in this manner. So she shot herself with the gun against the left temple, and the bullet was found at the back of her head. And no other theory was considered. And the problem with that is gunshot residue comes out of the barrel of the gun. So how would she get gunshot residue at the base of the palm of her hand if she'd shot herself in the manner I'm showing you? The answer is she wouldn't have. It's impossible. So instead of saying, well, therefore, she didn't commit suicide, she must have been murdered, and if she was murdered, her husband was the only one who could have done it, because they lived alone in their condominium in Quebec City. What the pathologist should have done is said, well, maybe she didn't shoot herself in this manner. Maybe there was another manner in which she shot herself. And if you look at the literature of gunshot suicides, you often see that the person who commits suicide holds the gun in this manner against their head and pulls the trigger, if only because it prevents recoil, because the gun is cushioned in your hand. And if you look, and this is a little bit bigger than the gun that was used, that she used to kill herself, you'll see that the barrel is adjacent to the base of the palm of her hand. But they never thought of that. They jumped to an immediate conclusion without using what's called the scientific method of considering all the possibilities. Now, you may well say, well, if she shot herself in this manner, then how would the bullet go from the entrance wound to the back of the head? Well, the answer is that the bullet, and we discovered all this after Jacques Delisle had been convicted of first-degree murder, we discovered that the pathologist had made another giant error at the autopsy. He had not appreciated that the bullet had not gone in the temple and traveled in a direct line to the back of her head where it was found inside her skull, but had in fact gone across her head or her brain after going through the skull and rebounded off the inside of the skull down to where it was found at the back of her head. A ricochet, in other words, which is, again, you only have to look at the books on gunshot deaths to see that ricochets, especially when a .22 is used, and it was a .22 that Nicole Ranville killed herself with, you expect ricochets within the skull because the bullet is not traveling with sufficient force to go through the skull one side, through the brain, and then exit the skull. It doesn't travel with sufficient force, and in fact, will usually, in about 50% of the cases, ricochet inside the skull and end up somewhere in the skull. Pathologists had never noticed that the bullet had traversed the brain across the head, and had never noticed from the x-rays that he took that there were bullet fragments on the right side of Nicole Ranville's head, which had been ripped off the bullet as it traveled after ricocheting as it traveled towards the back of the skull. And ultimately, in April of 2021, the Justice Minister, then Minister Lametti, quashed Jacques Delisle's conviction and directed a new trial. By that time, he'd already been in prison for 9 years, and he was 87 years old when he finally got released. So the pathologist can really mess things up at the beginning. Another case that we did just last year out of Ontario was the case of a man called Bernard Doyle. On a day in August of 1995, August the 4th of 1995, he was dancing in his apartment in Kitchener to music, holding his 14-month-old infant stepson in his arms. It was just the two of them in the home. He tripped over his tools. He was a roofer by trade. Fell face first so that his stepson, Tyler, the back of his head landed on the edges of the tools, and he died. The pathologist, whose opinion, incidentally, was subsequently endorsed by Charles Smith, said that the head injuries incurred by Tyler could not have been incurred by a short fall of a distance of 5 feet. And in fact, Tyler was the victim of a baby shaking incident and having his head banged against something like a wall. And despite Bernard Doyle telling the police from the outset what had happened, that he'd fallen and Tyler's head had struck, the back of his head had struck the tools on the floor, he was prosecuted and convicted of manslaughter. June 13th of last year, we got his case back into the Ontario Court of Appeal. And the court's opening lines were, "This is another in the long list of wrongful convictions brought about in part by the unreliable expert evidence of disgraced pathologist Dr. Charles Smith." And in commenting on the fresh evidence, they said, "The new evidence as to how Tyler died is consistent with the version of events that Mr. Doyle gave when he was arrested. He's entitled to an acquittal. There's no reasonable prospect of conviction if he was retried, so his appeal is allowed, his conviction set aside, and an acquittal entered." Of course, by that time, Bernard Doyle, who by this time was living in Newfoundland, which was where he was originally from, had already served the 4 years of the 4-year sentence that he had received. You move on from the pathologist, the police investigation can cause wrongful convictions, especially if there's a rush to judgment. The two cases with which I'm familiar and was involved in where there was a rush for judgment, it was something of an unusual rush to judgment, in that in both cases, that of Guy Paul Morin, convicted of the murder of Christine Jessup in Queensville, Ontario, and David Milgaard, convicted of the murder of a nurse, Gail Miller, on the streets of Saskatoon in 1969. In both those cases, they were unsolved for many months. And then the police, of course, being desperate to solve the cases, came across, in the one case, the neighbor, Guy Paul Morin. In the other, David Milgaard, who happened to have driven into Saskatoon that same morning from Regina, and desperate to solve the case, decided that they had committed the crimes, and from there constructed really a case of sand, but I'm afraid the sand was strong enough to convict both of them of crimes which they had nothing to do. David Milgaard, probably our most notorious wrongful conviction in Canadian history, spent 23 years in jail before he was finally released. And then 5 years after that, he was exonerated through DNA testing, and the real perpetrator, a man called Larry Fisher, was arrested 30 years after the crime, convicted of the murder, and died in jail some 8 or 9 years later. Both cases, there was a rush to judgment by the police. Understandable, human, you might say. They wanted to solve the cases. They hadn't solved them in all these months, and suddenly a new person came into their vision, and that person became not just the suspect, but the perpetrator in their minds. The credibility and reliability of witnesses can obviously play a significant role in a wrongful conviction. If the witnesses are not credible, if they're self-interested witnesses, for example, many cases of wrongful conviction, not just in Canada but other countries, the real perpetrator was the main Crown witness. Donald Marshall's case, the real perpetrator was a main Crown witness against Donald Marshall, claiming he saw Donald Marshall commit the crime that he, Roy Ebsery, committed. And there is also, when it comes to witnesses, the problem of mistaken witnesses. Not lying witnesses, but mistaken witnesses, particularly in the case of mistaken eyewitness identification. One of the more notorious ones in Ontario, indeed in Toronto, was the case of a man called Anthony Hannemeyer. On September the 29th of 1987, a man broke into a home in Scarborough, Ontario at 5 o'clock in the morning and attacked a 15-year-old girl while she lay in bed sleeping. Her mother heard the noise, got up, didn't know what was happening, got up, went into her daughter's bedroom, scared off the intruder, who ran out of the house and fled. It was decided that the crime was likely committed by someone who knew that the home was occupied by a single mother and her young daughter. And so suspicion fell on a roadworks crew who were working on the street nearby at the time. And one man who worked on that crew, Anthony Hannemeyer, had blonde hair which matched the description that the mother had given the police. She was shown a lineup, and she picked out Anthony Hannemeyer's picture from the lineup. It was subsequently discovered that she and the police officer who showed the lineup were actually in a relationship at the time, which obviously rendered the lineup result very dangerous. However, Anthony Hannemeyer was prosecuted, and in the middle of his trial pleaded guilty because his lawyer told him if he didn't, he'd get a sentence of 8 years, but if he did, he'd get a sentence of 2 years in the reformatory. So he pleaded guilty to avoid an 8-year sentence, pleaded guilty to a crime he didn't commit, although no one knew that at the time except Anthony Hannemeyer and the real perpetrator. It wasn't until 2005 that Paul Bernardo summoned the police to Kingston Penitentiary to confess to a bunch of crimes for which he hadn't been prosecuted, in the belief, as he told the police who went to interview him, that this might help him get parole at a future date, by showing his genuine remorse for his crimes. I have a funny feeling it won't help him, but that's beside the point. And one of the crimes he described was breaking into a house one evening, attacking a girl, and being disturbed by someone and fleeing. And he remembered the license plate of the car in the driveway, because the license plate of the car in the driveway was K-A-R, K-A-R. You can probably well imagine why he'd remember that. But for those of you who are young, it's because his girlfriend's name was Carla, K-A-R-L-A. Surprisingly, nothing was done about this. Nothing. Anthony Hannemeyer was not told that Bernardo had committed his crime. But we fortunately found out, because at the time we were representing Robert Baltovich, who was charged with killing his girlfriend in Scarborough, and we were alleging that Bernardo may well have been the perpetrator of that crime, which meant we had to get all the disclosure of everything about Bernardo given to us. And there, in the midst of all this disclosure, was Bernardo confessing to this crime that we realized someone else had been convicted of. We contacted Anthony Hannemeyer, and we reopened his case, and on August the 11th of 2008, this is what the court had to say. Mistaken eyewitness identification is the overwhelming factor leading to wrongful convictions. A study in the US of DNA exoneration shows that mistaken eyewitness identification was a factor in over 80% of their cases. I repeat what we said to Mr. Hannemeyer at the conclusion of the appeal. It is profoundly regrettable that errors in the justice system led to your miscarriage of justice and the devastating effect it had on you and your family. Another well-known cause is that of false confessions, whether extorted by the police or persuaded by the police or given at the instance of the person who makes the false confession for some psychological or other reason. Often, false confessions come from people who are vulnerable, developmentally handicapped people, for example. One person that the British government has acknowledged was wrongly executed in the 1950s as a result of a false confession was a developmentally disabled man called Timothy Evans. And he was convicted on the basis of his false confession to the murder of his wife and child. We recently had a case in Manitoba just last year. The case of Brian Anderson and Alan Woodhouse. Brian Anderson and Alan Woodhouse were members of the Pinemutang First Nation, Indigenous men, both late teenagers. Actually, one was 17, one was 19. Obviously, vulnerable individuals. And on Tuesday, July the 17th of 1973, a man called Ting Chen, who was a cook at a Chinese restaurant in Winnipeg, was viciously beaten and killed as he walked home on the streets of Winnipeg. His body was found the next morning. 4 Indigenous men who lived nearby, 2 of whom were Brian Anderson and Alan Woodhouse, were arrested, and it was claimed that all 4 of them confessed. All 4 of them, 2 of them didn't even speak English and yet managed to confess in English. They spoke the Saulteaux language, and having lived on the Fairford Reserve, part of the Pinemutang First Nation, did not speak, I mean, they spoke a few words of English. They certainly didn't speak the English that the police alleged they were able to speak when they gave their confession. Regardless of that, the system then was so corrupt when it came to the Indigenous that they were all convicted. On July 18th of last year, 50 years and a day after their arrests, Brian Anderson and Alan Woodhouse were acquitted in the Court of King's Bench in Winnipeg before the Chief Justice of the Court of King's Bench. The other two, one of them had died, and the fourth one, his case is still in the minister's office. There is no doubt at all that he too will get his acquittal one day in the next 12 months or so. And this is some of what the Chief Justice said on July 18th of last year when he had Brian Anderson and Alan Woodhouse standing before him. He said, "Understand that I speak publicly on a regular basis as a Chief Justice about the very positive features that a Canadian court and the judiciary in Canada possesses. I speak on behalf of the justice system, sometimes specifically the criminal justice system, and I regularly speak about how well we compare with other countries. But the grim and sad reality is that it is not a perfect system, and regrettably, when it fails, it can fail horribly. Brian Anderson and Alan Woodhouse, yours is just such a case. What happened in your case was what we must all battle against: individual and systemic racial discrimination. That is why we all continue to try to work toward a system where safeguards do not permit or tolerate a case like this one, where that individual and systemic racial discrimination dominated in the police investigation, in the prosecution, and ultimately the verdict itself." And when he said ultimately the verdict itself, he meant to include, I know, in that the trial judge as well. A trial judge who said to one of the accused during the course of the trial, "We don't live in trees anymore." Other causes, flawed science, whether it be a flawed scientist or whether the actual science itself has no reliability. A classic example of that was the use of so-called forensic hair comparison analysis, which was used particularly in murder trials for many years in Canada. It was said that if you took a hair from a crime scene and put it microscopically next to the hair from the believed suspect, you could tell whether or not they matched. 20 years ago, a little more than that now, 25 years ago, it was discovered that this so-called forensic ability was in fact nothing more than guesswork. The FBI did a series of studies where they took hair analysis results based on comparison microscopy and then did DNA analysis of the hairs to see whether indeed the hair microscopist had got it right. They found in 51% of the cases they got it wrong. So it was, you might say, legitimately guesswork. And we actually have a case right now of a man in Manitoba who's back before the Manitoba Court of Appeal after being convicted in 1995 in Winnipeg of 3 murders in a gangland slaying, based primarily on a hair that was found on one of the deceased that was said to match the hair of Robert Sanderson. We had DNA testing done, and indeed we discovered that we could say Robert Sanderson is the only person in the world we can say definitely did not leave that hair at the scene. And on that basis, his case now, 27 years later, is back before the Manitoba Court of Appeal. But I want to talk to you a little more today about how to catch wrongful convictions and also a little bit about how to prevent them in the future. And how we get it wrong, why we don't catch them much sooner than we do. It is often said in the media, by commentators particularly, when a person alleges that they were wrongly convicted. It's not conceivable they were wrongly convicted. They had a fair trial and they were convicted by a jury. Their conviction was upheld by the appeal court, and the appeal court's decision was upheld by the Supreme Court of Canada. With all those safeguards, it's inconceivable that this person was wrongly convicted and his claim should be treated as nonsense. Every time I see that, it gets up my spine, because it's wrong. Because our appeal process is not interested in guilt or innocence. Our appeal process is interested in process. Was the process at trial conducted correctly? Was the jury picked properly? Did the judge exclude evidence he should have? Did the judge allow in evidence he should have? Did he charge the jury correctly? Now, if any of those things went wrong, they may or may not have caused a wrongful conviction. But it's kind of chance whether or not they did. The focus is not on, was the person wrongly convicted? The focus is on, did they get a fair trial? Did they get the process that we say they should get? Unlike most European countries, in most European countries, appeal courts do look at issues of guilt and innocence. As a consequence, in a recent case, and I mean just 6 months ago, I guess 12 months ago, out of the Ontario Court of Appeal, it was said by a recently retired judge who's always acknowledged, and rightly so, as an expert in criminal law, Justice David Darchei, who had been on the Court of Appeal for more than 20 years. He said, in a case where the court did not quash a conviction, a first-degree murder case, that the prosecution's case was far from overwhelming. He said it twice in his judgment. And you might say to yourself, well, if a case is far from overwhelming, that kind of sounds like reasonable doubt. In fact, sounds like a lot more than reasonable doubt. And it does, and it is, but it's irrelevant. The man got a trial with a proper process. The fact that the evidence against him was seen by such an experienced criminal trial lawyer and criminal appeal judge as being far from overwhelming was irrelevant to his appeal. Section 686 of the Criminal Code says that an appeal court can quash a conviction if the verdict is unreasonable or cannot be supported by the evidence, or on any ground there was a miscarriage of justice. Whether a verdict is unreasonable or cannot be supported by the evidence is, as you can probably appreciate, listening to those words, a legal test, not a factual test. It's whether there was any evidence. In other words, the way it's always put is, was there sufficient evidence that a properly instructed jury acting judicially could have returned a conviction? Could have. That's all you need to survive the appeal process, absent an error of process in the course of the trial. And the idea that's in the code that a conviction can be quashed on any ground there was a miscarriage of justice, you might think, well, if a person's convicted in a case where the evidence is far from overwhelming, you might think that's a miscarriage of justice. No. A miscarriage of justice is interpreted to mean an error of process leading to a miscarriage of justice. You can't get away from that process. So what our appeal courts don't do is they don't examine a conviction to determine whether it's unsafe. Or, to use some of the other terminology used in other jurisdictions, they don't consider whether it gives rise to a lurking doubt as to whether the person committed the crime. They don't consider whether, as an appeal judge, they have a feeling of unease about the verdict. or they don't consider whether the evidence is far from overwhelming. In many jurisdictions, the UK being one of them, the word unsafe is in the powers of a court of appeal to quash a conviction if they feel the conviction is unsafe. So in 1992, in David Milgaard's case, when the Supreme Court of Canada quashed his conviction, after hearing new evidence and finding that the new evidence now created a reasonable doubt, but that's because there was new evidence. They didn't look at the record and say there was a doubt. They looked at the record and the new evidence and were able to decide there was a doubt. The Supreme Court couldn't resist saying at the outset, the first line, "It is appropriate to begin by stating that in our view, David Milgaard had the benefit of a fair trial in January 1970. So here we are, 23 years down the road. They're about to quash his conviction. And their opening line is, he had a fair trial. I mean, what a way to start it, really, when you think about it. I don't think David Milgaard thought he had a fair trial. And it highlights how, back in 1970, the Saskatchewan Court of Appeal sustained the conviction, and then in 1971, the Supreme Court of Canada sustained the conviction. They might have began their judgment by saying, as a court, we would like to begin by apologizing to David Milgaard that 22 years ago we got it wrong. No such chance. And the case of a man called Thomas Yebbies really sets the stage for how wrong the test is for an unreasonable verdict. It's the ultimate irony for the ages, the case of Thomas Yebbies, a case which continues to pollute our criminal law to the present day and continues to allow wrongful convictions to be upheld until a decade or decades later, 5 decades later, for Anderson and Woodhouse, it's finally corrected. Thomas Yebbies was a hairdresser. He lived with his wife in Surrey, British Columbia. In 1979, they adopted 2 boys from Chile. They were aged 5 and 4. And the adoption led to marital discord. And in 1981, 2 years after the boys arrived, Mrs. Yebbies moved out because she couldn't handle the boys, and Mr. Yebbies became their sole caregiver. On the night of February 23rd, 1982, Mr. Yebbies woke up in the home shortly after midnight to the smell of smoke. He rushed upstairs to find both boys lying on a burning mattress, already fatally overcome with smoke, on the mattress in their bedroom. There was a cigarette lighter and a candle in the bedroom, which you might have thought was a bit of a clue. However, 3 experts came forward and said, for their own different reasons, that the boys were both dead before the fire started. It began with the pathologist. Actually, it began with the fire marshal. The fire marshal said that the fire had been started with an accelerant, gasoline. Well, that meant murder, of course. The pathologist said that because there was no evidence of carbon in the boys' lungs, they must have been dead before the fire began. And a toxicologist said there was very little carbon monoxide in their hemoglobin, and so he too said they must have been dead before the smoke, before they inhaled smoke. And the theory was that they had a pillow placed over their faces and the fire then set. The trouble is they didn't have a motive for Thomas Yebbies to have killed the 2 children that he had taken on as a single parent. I mean, he loved these kids. He'd lost his wife because of them. He had stuck with them and lost his wife as a consequence. So the Crown manufactured a theory, as they do in these types of cases when there's no motive. They manufactured a motive. And if you really think it through, you could probably guess for yourself what the motive was. The motive was he wanted his wife back, so he killed the kids. That's why he did it. And he was prosecuted on that basis and convicted of 2 counts of murder. And since then, his case has become, as I say, a millstone around the necks of the criminal justice system, because he appealed on the basis that at a minimum there was a reasonable doubt as to his guilt, and the court should have a sense of unease about his conviction because he loved these boys. The British Columbia Court of Appeal dismissed his appeal, saying that the verdict did not meet the unreasonable verdict legal test. One judge dissented. His name was, actually, I've forgotten his name. But the case then went to the Supreme Court of Canada. And in 1984, the Supreme Court of Canada concluded that the verdict was one that a properly instructed jury acting reasonably could have rendered. And as the judge put it, his name was McIntyre, put it, I'm of the view that there was some evidence before the jury on which a jury could reasonably have reached the conclusion that Mr. Yebbies had exclusive opportunity to kill the boys. And since only he had the opportunity, as well as the motive, to commit the crime, we uphold his conviction. And since then, right up to now, his case has become the go-to case whenever a conviction is factually attacked on appeal. I tried to look up how many times it's been cited, and it's been cited in appeal cases more than 5,000 times since its decision in 1985. Fast forward 38 years to 2020. Mr. Yebbies' nephew had always been convinced of his uncle's innocence. He went to law school in BC, and he immediately joined the law school's Innocence Project. And he convinced them to take on his uncle's case. And they did. They went to a fire expert who said the fire marshal's opinion that the fire was started by an accelerant was absolutely wrong. They went to a pathologist who said that the absence of carbon in the lungs was neither here nor there when it came to whether they had died of smoke inhalation. They went to a toxicologist who said the absence of substantial amounts of carbon monoxide in the hemoglobin was irrelevant to whether the boys had died as a consequence of smoke inhalation. The Crown then retained their own experts in the same fields, all 3 of whom came to the exact same conclusions. And on November the 5th of 2020, the minister, again, Minister Lametti, with the power that he has, quashed Mr. Yebbies' conviction and directed a new trial, the highest power he has. And a week later, on November the 14th of 2020, Thomas Yebbies appeared back in the British Columbia Supreme Court. The Crown acknowledged his innocence, offered no evidence, and he was acquitted with apologies. Taken 37 years. But you know, law books don't and won't tell us what actually happened in his case. They'll continue to cite the Yebbies case as authority for what it is authority for. And the appeal courts since 2020 have continued to cite Yebbies. Indeed, the case that I spoke to where Justice Doherty said that the evidence was far from overwhelming, what case did he rely on in dismissing the appeal? Mr. Yebbies' case. That's called not learning from experience. I think it's fair to say. And if you look at some of the more notorious wrongful convictions in Canada, you will quickly see how the appeal courts have let us down. In the Ontario Court of Appeal, by way of preface, as far as I know, in the last 30 years, 2 murder convictions have been set aside on the grounds they were unreasonable verdicts. Only 2, and the individuals acquitted. I might say in both of those cases, as you read them, you actually get the strong impression that it may well be they committed the crimes. You don't really have that sense of unease, but what's missing is an essential little piece of evidence that gives you a case that puts it over the hill of being sufficient evidence to warrant a conviction by a jury. A demonstration of how it's a legal test and not a factual test. But look at the cases, the more notorious cases that have gone straight through the appeal courts with nary a worry on their part. David Milgaard, I've already mentioned, went through the Saskatoon Court of Appeal and the Supreme Court of Canada back in the early 70s without a problem at all as far as they were concerned. His conviction was premised primarily on flawed police work. He spent 23 years in jail, 28 years before DNA testing proved his innocence. Clayton Johnson was convicted as a result of flawed pathology in the death of his wife. She died as a result of a fall down the stairs, not as a result of having her head beaten in with a baseball bat, which was the Crown theory on which Clayton Johnson was convicted in Shelburne, Nova Scotia. His case sailed through the Nova Scotia Court of Appeal and the Supreme Court of Canada. It wasn't until some 12 years later that his conviction was eventually quashed and he was acquitted and acknowledged to have been an innocent man. Stephen Truscott, a victim as a 14-year-old boy in 1959 in Goderich, Ontario, of flawed pathology and non-disclosure of what prosecution witnesses had originally told the police. Sentenced to death at the age of 14, ultimately reprieved. His case went through the Ontario Court of Appeal and the Supreme Court of Canada twice, but failed both times. And it wasn't until 2007 that he was finally exonerated in the Court of Appeal. Aaron Walsh spent 25 years in jail in New Brunswick for a murder he didn't commit that went through the New Brunswick Court of Appeal and the Supreme Court of Canada. Romeo Filion spent 32 years in jail for an Ottawa murder that he didn't commit. And so on and so on, through so many of the wrongful convictions that have happened in our country. Brian Anderson and A.J. Woodhouse, the 2 Indigenous men, or Alan Woodhouse, the 2 Indigenous men in Winnipeg last year. They went through the appeal courts as well. So if we have a failing in our system, and it's a failing that will always make me angry, it is that our appeal courts fail us when it comes to finding and correcting wrongful convictions. In 2021, Minister Lametti asked 2 ex-judges, 2 retired judges, Harry Laforme, the first Indigenous person appointed to an appeal court in Canada, and Juanita Westmoreland Traore, the first black judge ever appointed in Quebec, to hold public consultations on, amongst other things, our appeal system. And they concluded that grounds of appeal from conviction should be expanded to include a power to quash a conviction when the appeal court had a lurking doubt about that conviction. They said, the grounds of appeal should be expanded to allow courts of appeal to overturn convictions, in addition to the existing grounds. The approach taken by the Supreme Court to the ability of appellate courts to overturn convictions in the leading unreasonable verdict case of Yebbies recognize the inevitability of wrongful convictions. It should be updated. The current test for appellate intervention relies heavily on judicial experience. The lack of diversity in the judiciary and the lack of universal judicial understanding of the causes and consequences of wrongful convictions concern us. Appellate courts can be especially deferential to determinations by trial judges or juries about whether a witness is telling the truth, a factor that may also be influenced by unconscious bias based on the appearance and presentation of witnesses. The current test also creates more barriers to appeal from convictions by juries as well as judge alone without a jury trials. The other problem we have in Canada with exposing wrongful convictions is our last resort process. Appeals are ultimately not quite the last resort. For 99% of the cases, they are the last resort. But there is another last resort that you can bring an application for what's called ministerial review under the Criminal Code to the Minister of Justice of the day. And if you can satisfy the Minister of Justice that there, these are the words, a reasonable basis to conclude that a miscarriage of justice likely occurred in your case, then the minister can quash your conviction and direct a new trial. Since 1997, there have been 36 ministerial references of convictions in Canada, 27 of which were convictions for murder. That's not very many. That's pretty well one a year, bit more. It's also a very slow and unsatisfactory process. And we at Innocence Canada have been pushing for change for 31 years to get rid of the ministerial process that dates back to 19th century English statutory law. England doesn't use it anymore. They abolished their system of ministerial reference or ministerial review back in 1997. That's why I gave you the numbers from 1997. They created a new independent tribunal called a Criminal Cases Review Commission. It's a bit of a flat name, but that's what it's called. But it's done good work. The commission, which works on cases in England, Wales, and Northern Ireland, not Scotland, England, Wales, and Northern Ireland, which has a population, our population is about 67% of the population of England, Wales, and Northern Ireland. In the period, we've had 36 ministerial references, 27 of which were murders. In that same period, the Criminal Cases Review Commission has referred 723 convictions as unsafe, 558 of which were quashed by the appeal courts, 182 of which were homicides. So you can see this extraordinary discrepancy in the consequences of the two different systems. Scotland has its own Criminal Cases Review Commission. You may not know, but Scotland has its own criminal justice system, separate and apart from the British system, or from the English system, perhaps I should say. They have 1/7 of our population. And in that same, well, 2 years more, their commission didn't come into being until 1999. In that period of time, they've had 86 convictions referred, 52 of which were homicides. Again, you can see the enormous discrepancy in the figures. If you multiply those figures by 7, so you get the Canadian equivalent, you've got what? Something like more than 600 convictions have been referred in the period that we've had 36. And in February of last year, Minister Lametti, the former Justice Minister, introduced Bill C-40 before Parliament. He called it David and Joyce Milgaard's Law, to create a new commission to be called the Miscarriage of Justice Review Commission. The bill has gone through second reading. It got held up by Mr. Poilievre's filibuster over the carbon tax, if you can believe it. But it's still wending its way slowly through the parliamentary process and is due for third reading and to go to the Senate sooner rather than later, I hope. Because if this government doesn't enact it and they don't survive the next election, we can say goodbye to a miscarriage of justice review commission. Of that, I have no doubt. And the commission, if it comes into being, will have somewhere between 5 and 9 commissioners, not enough, but something, at least a third of whom must be lawyers, which means as many as 2/3 don't have to be lawyers, which to me is good. And in making recommendations for commissioner appointments, the minister is directed by the legislation as it presently stands, or the bill. The minister, quote, must seek to reflect the diversity of Canadian society and take into account considerations such as gender equality and the overrepresentation of certain groups in the criminal justice system, including Indigenous peoples and Black persons. And then the commission, in determining whether there's been a miscarriage of justice in a case brought before it, is directed to consider, among other things, and I quote, the distinct challenges that applicants who belong to certain populations face in obtaining a remedy for a miscarriage of justice, with particular attention to the circumstances of Indigenous or Black applicants. And if enacted, and I sure pray it will be, it's a good place to pray, it will be a sea change for the wrongly convicted. Just remember the stats from England, Wales, Northern Ireland, and Scotland. The 2 commissions that they have. New Zealand just brought one in about 3 years ago, and already they're starting to refer miscarriages or uncover miscarriages of justice. So, as I say, let us pray. The other thing it can do, which I think is immensely important, but you wouldn't necessarily think of off the top, is something that it's done in England. It has enabled relatives of persons hanged for crimes they didn't commit when the death penalty was in force in England to seek exoneration through the commission, the Criminal Cases Review Commission, as it's called. And 3 men, all executed between 1950 and 1951, to be exonerated in the years since the commission came into being. One of the saddest cases was a man called Mahmoud Matan. Mahmoud Matan had jumped ship. He was a merchant navy man, a Somalian, who jumped ship in Cardiff, Wales in 1949 when he met a local resident of Cardiff, fell in love with her, and they married. In 1951, a shopkeeper called Lily Volpert was murdered in her shop during a robbery. Her throat was slit. Mahmoud Matan was charged, convicted, and on September the 8th of 1952, he was hanged for a crime he didn't commit. His case was referred by the Criminal Cases Review Commission in 1997 back to the Court of Appeal as a miscarriage of justice. And in 1998, the Court of Appeal acknowledged that indeed Mahmoud Matan was an innocent man and had been hanged for a crime he didn't commit. The real perpetrator was the main Crown witness, who had made up, he knew, if you accuse a Black man in Cardiff in 1951, you were going to convict him. And the judge, his name is Lord Justice Rose, who headed the panel that quashed Mr. Matan's conviction, said, and I quote, and I only quote it because he said it so well, "It is, of course, a matter of very profound regret that in 1952, Mahmoud Matan was convicted and hanged, and it's taken 46 years for that conviction to be shown to have been wrong. Capital punishment was not perhaps a prudent culmination for a criminal justice system which is human and therefore fallible. Beautiful words when you think about it. And one thing we're ready to go on, if we get a commission here, is we have a number of what we believe may be wrongful executions to take before the commission. One is the case of a man called Daniel Sampson. Daniel Sampson was a 49-year-old black laborer executed in Halifax, Nova Scotia for 2 homicides, where his conviction was premised entirely on a confession, which he signed with an X because he couldn't write his own name. Another one is closer to home, a Toronto case. A man called Abraham Steinberg, convicted of the March 5th, 1930 murder of a fellow businessman. They made monuments at Dundas and St. Patrick Streets in downtown Toronto. And someone shot Samuel Goldberg in the head on March 5th of 1930. And Abraham Steinberg, perhaps despite his alibi, was convicted and hanged on July the 14th of 1931 in the Don jail. On suspect there may have been racial bias involved in that case. And then there's the case of Wilbert Coffin, of which some of you may have heard, executed in the Bordeaux prison in Montreal on February the 10th of 1956 for a triple homicide of 3 American tourists in the Gaspé, murdered in the forest. They were hunters, where there was an extraordinary push by Duplessis, the then premier, to push for the police to solve the case and to convict and hang Wilbert Coffin in order to appease the Americans to encourage or to avoid discouraging the tourist trade. And interestingly, in all 3 of those cases, we've been in touch with relatives of the individuals. So to conclude, wrongful conviction work it's good work. It's demanding, it can be very uphill sometimes, but it is immensely rewarding. Just to give you an idea of what may be coming, we're working at the moment with confidence on a 1994 triple homicide out of Winnipeg, a 1993 homicide case involving 2 Indigenous sisters convicted in Kamsack, Saskatchewan of homicide, a man convicted of a 1994 murder in British Columbia, a woman convicted of murdering her son, her infant son, in Cornwall, Ontario in 1998. A man convicted of murder in Edmonton, Alberta, back in 1992, I believe it was. And a month from now, a 1980 homicide from Etobicoke is going to be back in the Court of Appeal, a man called Tim Reese. And there's going to be a week of cross-examinations before the court of police officers who, we allege, suppressed essential exculpatory information that would have proved who really committed the crime, not Tim Reese, but another man who lived in the same house as Tim Reese, who we have every reason to believe committed the crime, and who we believe we can prove committed the crime based on evidence that the police had in their possession back in 1989, but withheld from the defense and probably the Crown as well. So there's no shortage of work, and perhaps you have me back in 10 years, I'll be able to tell you about a whole bunch of new cases. But thank you so much for having me. Yes, of course I will.
Well, much to think about and ponder. And while you're doing that, grab your pens, write your questions, hold them up. Ryan and Susan will be coming around to, Sharon rather, sorry, to pick them up momentarily. But in the meantime, the folks on Zoom had the jump on you because they could put their questions in the chat while Mr. Lockyer was talking. So I'm going to ask Sylvia to, we're going to try to synthesize. We have, I should say, we have about 12 minutes. We will wrap up, and then you're all invited to a reception one floor below, and I'm sure Mr. Lockyer will be glad to join us, and you can try to ask more questions then, but give him a little time to take a breath. So, Sylvia, what have you got?
Okay, so I'm actually going to start with not the first question to come in, but one that two different people asked. And that is, does the state compensate someone for their experience, their loss of, liberty and everything else that they lose when they're exonerated for a wrongful conviction?
Shall I stand? I project better
if you're sure, if you like,
Yeah.
I mean, however you're most
People can
comfortable.
see me, and
I think, well, somebody will tell us we can't.
Well, the answer to that question surprises a lot of people. There is no right of compensation if you're wrongly convicted. Even if the court acknowledges that you were wrongly convicted, the court exonerates you, the system can do that, but you still have no entitlement to compensation. The only right you have is a right to sue for wrongful conduct by the police or perhaps by some other government agent. Pathologists you can't sue because pathologists have absolute immunity from being sued. You can't, forensic scientists, I don't know if you can sue forensic scientists, maybe you can. But you have to demonstrate negligence. Now, in some wrongful convictions, that's easy. But in many, it's not. In some cases, I mean, take Anthony Hannemeyer's case. Well, perhaps it's not such a good example. But take a case of an average, or an ordinary, if that's the right word, case of mistaken eyewitness identification. That may not have come about through police negligence at all. It's just the witness made an honest identification, but misidentification. So in those circumstances, you'd have no one to sue in tort. All you can do is ask government to make what's called an ex gratia payment to you, meaning a payment they don't have to make, but they might make out of the goodness of their heart if you ask for it. Bernard Doyle, whose case I told you about, acquitted last year, in June of last year in the Ontario Court of Appeal, has no ability to sue. He has no one to sue. You can't say the police were negligent, they relied on the pathology. Even if you could say the pathology is negligent, which isn't entirely clear, because back in the day, it was thought that short falls could not cause death. Now it's well known that they can. Back then it wasn't so well known. So even if you could sue the pathologist, which you probably can't because they have absolute immunity, Bernard Doyle would not be able to sue. So we have asked for the government make him an ex gratia payment. We don't yet have a response, but we are hoping that he'll get a favorable response. He truly deserves compensation for what he went through, because he didn't just lose the stepson, who he was genuinely connected to and genuinely loved both ways. But of course, he lost the mother. The mother thinks he killed her daughter, her son rather. He lost all his friends in where it happened. Tragic. And his conviction went with him to Newfoundland. Newfoundland's a small place. Everybody sort of knows everything about everybody else. So people in Newfoundland knew that he'd been convicted of this awful crime of killing a 14-month-old infant. So the answer to your question is sometimes they'll get compensated and sometimes they won't.
Thank you. There were a few other questions along those lines. So, but I'm going to move on to something else, Sylvia, and then I'll come back to you. Interesting question. Someone asked that you focused on wrongful murder convictions because the sentences likely are the most severe, or have you focused on wrongful murder convictions because the sentences are the most severe, or are murder cases particularly susceptible to result in wrongful convictions? And I would
That's
add,
a good question.
What other types of
Yes.
convictions do you find?
Okay, first of all, yes, we do tend to focus on murder convictions, although we've done others. Anthony Hannemeyer, he was convicted of break and enter with intent to commit sexual assault. Remember, he was convicted of Bernardo's crime of breaking into that house. That was not a murder. And we've had a number of other cases that did not involve murders, but most of the cases we do are murder cases because, first of all, they're much more serious, and also the individuals are more likely to be in jail, so there's a more of an urgency. And if they're not in jail, they're on life parole for sure. So if you take the Anderson Woodhouse case, for example, the four Indigenous men, I told you that one of them is still in the ministerial review process. When we started that process for Brian Anderson and Alan Woodhouse, we didn't know where the third and fourth men were. Unbeknownst to us, one was dead, Russell Woodhouse had died, and the fourth one, Clarence Woodhouse, we couldn't find. And the reason we couldn't find him is because his parole had been revoked and he was back in jail some 35 years after his conviction, because he was on life parole. If you're on life parole, it takes next to nothing to put you back in jail for another 5-10 years before they release you on parole again. Now, the second part of the question was, are wrongful convictions more likely to happen in murder cases? First of all, in the United States, the answer to that question is definitely. No question at all. The United States judicial system, first of all, they have a death penalty. And once you bring a death penalty into a case, you immediately multiply the likelihood of wrongful conviction.
Why?
Why? Because of the stakes. The stakes are so high that the prosecutors and the police will do whatever's necessary to get their death penalty. And beyond that, the individual who's facing the death penalty will get offered, very often get offered a plea for life without parole. And many of the wrongful conviction cases uncovered by the Innocence Project in New York have involved people who pleaded guilty to murder in order to avoid the death penalty. And DNA has proved they didn't commit the crime. In Canada, it's a harder question to answer because there's no statistics. I can't tell you how many wrongful convictions of murder there have been or are now in Canada. I can't tell you how many people have been wrongly convicted of break and enter, sexual assault, theft, whatever you want to say. So I can't do a comparison. I can only say that most of our wrongful convictions have been in murder cases. But as I say, I can't tell you if they're more likely in murder cases or not. It's just we will more likely uncover wrongful convictions in murder cases because we're more likely to look at murder cases. A new commission, on the other hand, that's coming in under Bill C-40 will look at all crimes. And if you remember the stats that I gave you from England and Scotland for the operation of those two commissions, I don't have the numbers in front of me at the moment, they're somewhere buried in my notes, but I think I'm right in saying about a fifth of the wrongful convictions in those two jurisdictions were homicides. So that tells you that perhaps there is no, they don't arise more often in homicides than in other crimes. I don't know.
Thank you. Sylvia?
Sure. someone called Jeff O'Brien says, 20 years ago in R.V. Shearing, Justice Binney cautioned trial courts against turning men accused of sexual assault into second-class litigants. But that's exactly what happened with Justice Brown writing in dissent in RVJJ that Parliament has guaranteed that there will be wrongful convictions for sexual assault. What do you see as the solution to this problem?
Oh, that's dangerous
Sounds
ground.
like a law school
That's,
seminar.
Well, it's
It
dangerous
does,
ground,
doesn't it?
too.
Yes.
For a bunch of reasons, yeah.
As you know, there's been a very strong movement to make it easier to convict people of sexual assault crimes, and there's no question that statutory change and the interpretation of that statutory change, particularly by the Supreme Court of Canada, indeed they just came out with a judgment last week that I found concerning, where a man was convicted of sexually assaulting his ex-wife, who testified that they were, by this time, in a purely platonic, since their separation, their relationship had been purely platonic, and ergo, he had sexually assaulted her. She wouldn't have had sex with him she wouldn't have had sex with him unless he had forced it on her. And he wanted to lead evidence that the day prior to the alleged sexual assault, they'd actually had consensual sex. And he wasn't allowed to lead that evidence. I find that concerning, I must say. But there's no doubt that the way, I think a lot of people will say to you that far more people get away with sexual assaults that they committed than are convicted, perhaps, of sexual assaults that they didn't commit. That brings back, the old thing about what's best for our society. It's so often been said that 9 acquittals of guilty people is better than 1 conviction of an innocent man. Some people have said 99 people acquitted of something they actually did is better than 1 person wrongly convicted. It's a judgment that we all have to make. I always remember reading, I found it quite chilling, that one of the, I forget his name now, but the Attorney General, Ronald Reagan's Attorney General.
Edwin Meese? No.
Yes, thank you, Edwin Meese. Edwin Meese wrote a piece in a periodical, one of the law journals. The anti-death penalty movement had been writing a number of articles about people who have been wrongly convicted and were either on death row or had been executed. Indeed, someone had written a book about it. A man called Michael Radillette had written a whole book about people who had been wrongly executed or wrongly put on death row in the US. And Edwin Meese wrote an article in a law journal upholding, saying the death penalty should be upheld, even though, he said, inevitably innocent people will be executed. I found that chilling.
It is rather chilling.
It is a little bit.
So we are running out of time. I'm going to ask one more question. I'm going to change tacks. There's lots of great questions, and hopefully you'll
So
be
many.
able to answer them individually, or who knows, maybe we'll invite you back. And this one has to do with the people who are wrongfully convicted, not the system or the systemic issues. And that is, how functional are the lives of some of these people after they're leaving prison? And can you give us some examples of how people have
That's a really good
fared
question.
having been?
There's something about being convicted of a crime you didn't commit that makes you into an awfully good person. I don't know what it is, but whilst they have a certain degree of bitterness, inevitably, they are, I suppose it's such a long process setting aside a wrongful conviction. It means that perhaps for the last 5-10 years of their time in prison, they see a group of people working for them. I've never thought of that before, but maybe that's what it is. It could be something to do with it. And so they see, people working for them, and it restores their faith. But generally, I can tell you that the wrongly convicted people that I've met, and I've met wrongly convicted people from the UK, obviously from Canada, and from the US, probably as many as 200 in my time, have all been really marvelous people. And the more you get to know them, the more marvelous. They can also have a great sense of humor. I'll always remember the day that Guy Paul Morin was acquitted in the Court of Appeal and exonerated through DNA testing. We'd actually only got the results about 5 days before his appeal was due to be heard in January of 1995. And so just that few days later, we traipsed into the Court of Appeal, and Guy Paul is acquitted. And we held a press conference afterwards, and one of the, we've been talking about the DNA and so on and so forth, and one of the reporters asked Guy Paul, he yelled out to him, "Guy Paul," he said, "you seem so calm and so assured, no bitterness. I can't see any bitterness in you. How come?" And Guy Paul came back with the perfect answer. He said, "It must be in the genes." And the room exploded. But, you know, some do have problems. I mean, I spoke of the 2 Indigenous women from Saskatchewan. We got them bail in March of last year after they'd been in jail for 30 years. And they were both released while we await the minister's decision on their case, which is probably still going to be another year or more from now. And one of them, Narissa, and this is public record, I'm not telling you something I shouldn't be telling you, but Narissa, both sisters are victims of residential schools in Kamsack, Saskatchewan. Both were teenagers when they were arrested for the murder that we say they didn't commit, and both spent 30 years in jail, and suddenly they're released. And Narissa, I hate to say, has messed up. These really, in my view, rather, I don't like to say unnecessary, but really stringent conditions were placed on them. And one of them was a curfew. And Narissa was incapable of obeying her curfew, incapable of it. She broke it every single day. And she got rearrested, her bail was cancelled, and she's back in. Now, that's nothing to do with her character. That's to do with her life, I suppose you could say. The life that she's had to go through. Residential school, followed by 30 years of the penitentiary. Can you really expect her to be able to not just live a life of freedom without getting into trouble, but live a life of freedom with all these serious constraints placed upon her as to what she can and can't do during her freedom? And she's institutionalized. Of course she's institutionalized. She's the first to admit it. She spent her life being told what to do and when and how to do it. And suddenly she's free, and she's still being told what to do, how to do it and when, albeit to a lesser extent. But now she's free to ignore it, albeit there are consequences. And so, you know, it can be a real problem for them to get back into the world and live in our world as opposed to the world they'd lived all those years.
Thank you, Mr. Lockyer. I'm aware and want to be respectful of your time and everyone else's. And I think the measure of the impact of your remarks and the engagement are the number of questions that have gone unanswered. But we will have a chance to have some discussion. So I want to thank you for giving us such a thorough understanding and also pointing to some ways perhaps we can support the passage of the legislation and make us understand that there are better ways of doing this. It's not all hopeless, which is these days a nice feeling. And just before we say goodnight and invite you one floor below to enjoy some refreshments, I'm going to ask our Rabbi Ryan Leshner, to welcome you again or send you on your way and to thank Mr. Lockyer. Thank you.
You have to put me in between this and food. It's a tough act.
When you sing a Donald?
This is when we sing Adon Olam. This is how we do it, exactly. I'm Rabbi Ryan Lesner. Welcome, everyone. It's so great to see familiar faces, and it's great to see some new faces. It's an absolute pleasure to be here. And I want to thank Mr. James Lockyer, first and foremost. Thank you for sharing. I don't know if you know this, but you actually taught us the most important thing in the Torah this evening.
Which was?
I'll tell you. Okay. I'll tell you exactly. For those of us who have stepped foot into a synagogue or have read a Jewish book or have been around Jewish people, you may have heard this phrase, tikkun olam. Sound familiar? Some nods. Fantastic. I learned very recently that we've been doing it wrong. We've been doing it wrong. The way I understood tikkun olam as it was brought up to me is that you go and you do these wonderful acts for the betterment of repairing the world. Tikkun olam literally means to repair, to fix the world, olam. And you do these wonderful things. You go out and you give change to somebody who is unhoused. It's a beautiful thing. You go and make sandwiches with an organization, give it to a food bank. That's a wonderful thing to do, and we call that tikkun olam. But if we go to our Torah, and if we go to our Mishnah, and we go to our sacred texts, it tells us something different, which is that tikkun olam, literally if you see it in the text, this is your Hebrew lesson for the day, it says mipnei tikkun haolam. So it'll give you an example of some sort of civil case, or some sort of example of how society is acting in a certain time, and it'll say, here's the problem, and here's our solution, mipnei tikkun haolam, which means for the betterment or because of repairing the world. And what's interesting about this is that we're not talking about these acts of goodness, right? These one-time acts of going and giving a donation to a charity or giving a sandwich to someone who needs a sandwich. We're talking about legal proceeding to make sure that we are taking care of the society in our world. So what that looks like then, if we're going to use that definition of tikkun olam is the act of working towards immediate resolution, right? It's present actions. We're not talking about past or about future. Present actions of how we can make our world, our society better. It's a legal term. It's a legal term is what it is. And what we call tikkun olam, I'll argue, another beautiful thing to do, it's a beautiful thing to go and give some spare change to somebody. It's a wonderful thing to give a sandwich. That's an act of chesed. It's an act of righteousness. It's a really beautiful thing to be able to do. And we need both. In our society, in our life, we desperately need both. And so, what you've taught us this evening is mipnei tikkun haolam, about ways in which we recognize and we recognize systemic racism, wrongful convictions, we recognize that there are flaws in our system, we recognize that this system that we are a part of is a deeply human system, and it is flawed, and it is on us to make it better for the betterment of repairing the world. So you brought us some incredible Torah this evening, my friend. And so, with that little bit of Torah, there's a whole bunch of people to thank. First and foremost, James, for being here and for sharing your Torah with us. Please come on back. Please come on back. Please and thank you. You mentioned Temple Emmanuel, which is the synagogue I grew up at as I was growing up here, and now you're here at Darchei Noam. Those are the only two synagogues that you mentioned, the only ones you remember. And so...
He's following you.
Right, and so you're doing good work, right? You're associating yourself with good places. We'll welcome you back.
In 1979 was a long time ago, so I can't remember.
Well, we'll have you back anytime. You're always welcome here. I would like to thank Esther, Sylvia. I hear Kathy Sikora may be on Zoom. Thank you, Kathy, for all that you do to make things run smoothly. I would like to thank Rohan, who is somewhere in the building. I'd like to thank Jomar, who's helping with some tech support. I would like to thank Danielle, who is going to give you some wonderful food one floor below once I'm done speaking. And I would like to thank someone who never gets thanked here, our friend Adrian, who's at the door, who's making sure that people who come in are here for the right reasons and making sure that we're safe. Please, as you're leaving, tell Adrian that you all say, but say I said it. Thank you from the bottom of our hearts. I love him. I love having him here. He's a great gift to us. None of this would have happened without the hard work and dedication of the Social Justice and Advocacy Committee. If you are a part of this committee, could I ask you to rise? If you currently sit on this community, can I ask you to rise? And let's give a round of applause. And now, Don't you worry. And now, hold on. Now, if there are people who are stepping down from this committee, could I ask you to rise? After 3 years of service, there are some folks who are stepping down from this committee. Meyer, you're one of them. You have to stand. Thank you. We give a round of applause for these wonderful people. And we recognize them after 3 years of serving as a member of the Social Justice and Advocacy Committee. We thank you for your service and for working with us. And we invite, for anybody who would like to come onto our committee, we have some new faces who are here. Come and be a part of it. It's a wonderful and amazing, beautiful place that I'm really grateful that we have here at Darchei Noam. And of course, we cannot have this evening without talking about the Merkur family, particularly Lorne. Thinking about Lorne Merkur, who made it happen to make sure that we have this series that happens each and every year around equity, civil liberty, and social justice. He did this to honor you, Myra, and your family and your contributions to our community. And so while he is not here physically, he's certainly with us in spirit. Come on up, please.
I don't know where to begin, but of course my heart is with my grandchildren who are here today, and to my son and to his partner. I walked in the door, and there wasn't one smiling face for me. There was all smiling faces. And it feels, this is my home. I belong here. And I'm so happy when Lorne decided what to do, he told me what he was going to do. This is kind of an old story for some and not for others. Lorne was an important person, not just my son. He was always there when he knew his mother might need a little help. And he was always there for me. So one year, many years ago, it seems like many years ago, I'm not quite sure how long ago it was, I said to him, you know, Lorne, I'm not going to wait till I leave this earth. I'm not going to wait until I go, because I plan to be here for a while. So I said, please let me give you a gift. And I gave him a large sum of money. And I said, you're worth every cent of it. He said, thank you. He says, Mom, but I don't want this money. I said, well, it's yours. So he came to Darchei Noam, and he said, at the time, we spoke to the rabbi, and he knew how much I loved it here, and he loved coming here as well. And he said, and there were, I think there were a couple people there the day that we gave it to Darchei Noam, and that was, you know, very much appreciated. And and he said, there's one thing, he said, I know my mother will always be interested in giving and doing. He said, so I want to honor her with this gift. And so I got this beautiful letter with him saying, I'm happy to donate this money to. And he earned every bit of that money. He worked hard for me and put me on the right track in areas that were very difficult for me, and made me feel okay about it. He made me feel that it was okay to ask him to do this for me. And I said, I'm asking the right person, because boy, do you know how to go do this quickly. And I don't even understand it. So I want to thank Darchei Noam for helping I was hoping that he would always be here on this night. But I think he's in our hearts. He's in my grandchildren's hearts tonight, and my son and his partner. And I have a feeling, as I look around the room, I think you know where I'm coming from. So I thank Darchei, Noam, and I thank the rabbis here, and I thank you very much. I couldn't believe how much you carried in your mind and was able to put it out that we could understand. And you just looked at your notes once in a while. Well, I decided to be like him for a few minutes.
Thank you, Myra. And the last thank you is to each and every one of you for being here and being a part of it. It's time to get to work. If this is your first time at Darchei Noam, don't hesitate to introduce yourself to me or to anybody else here. There are familiar faces everywhere. We're so happy that you're here. Go downstairs and eat. From Rabbi Tina and I, thank you for being here, everyone, truly.